All right, good morning. Good morning. Hope everyone's doing well. You had a good weekend. So you all know your midterm is coming up very soon. I actually have to write it soon. But it's about, I think, 2 weeks, right? So the setup will be you come here. One of my research assistants will be proctoring. I will not be here. You will have, ExamSoft. They actually sent me instructions on how to use the word count. Let me show them to you. I actually asked. They sent me something. Let me pull it up. Okay. So again, you'll be getting exam numbers from the registrar. These are different than your final exam number. They're different. Don't use your final exam number. The reason why is we don't want me to know who you are, right? The purpose of this is anonymity. If you give me your final exam review number, then I know who you are. So they're going to give you a special number just for the midterm. Also, don't put your G number, your South Texas number. That won't help me. I have no idea what that is. I'm not supposed to know that. So they'll give you a number. If you don't get it the week before the exam, tell me, and then I'll go inquire further. But they should give it to you, okay? So pay attention to this, right? So in Exemplify, which is the software, you'll see there's an option for character count, right? A character is a letter or a space or a number, right? A text message is roughly 250 characters. A tweet was 140, now it's 280 characters, right? These are short things. What you have to do, okay, is click on the little icon next to the character count. If you click on the icon next to the character count, it will show you the word count. Again, it displays the character count automatically, which is a worthless metric. I don't know why it does it, but it does it. If you click the little document icon, it'll show you the word count. Okay? The midterm's only one question, so you only have to worry about the word count for one of the questions. The final will be 2 questions. So there'll be box number 1 for question number 1, and then box number 2 for question number 2. It'll separate your word counts. Please do this so I know the word count for one and word count for the other. I don't want to just see the total. Okay? If that doesn't make sense to you, go to the registrar. They will walk you through it. That's my spiel on that. All right, any questions there?
Do we have to do an individual word count for each question on the final, or did they need to talk with the registrar about that?
Well, the final, there are 2 questions. So if you put, see there's 1, 2, 3, 4, 5 on the side?
Perfect.
If you put question number 1 in box number 1, and question number 2 in box number 2, it will do it automatically. But you just have to make sure you do your word count by yourself. Okay? Yeah. I actually, when I was taking the bar years ago, I screwed this up, where there was question 1 had like 5 parts. And I put part number 1 into question 1 here, and part number 2 there, 3, 4, 5. And then by the time I got to question number 2, there was nowhere else to put it. So I put like my entire exam in box number 5, right? The entire exam. It didn't matter. But, you know, you can't cut and paste on the bar. So I just went for it. People actually, I was shocked. They actually thought, oh no, they actually started deleting their stuff and retyping it, which is insane. You don't want to waste your time. In the event that you mess this up, I'll figure it out, but it makes your life easier. Okay. Any other questions on the exam or ExamSoft? All right. Let's do a polling question. This one will be a little bit tricky to see how you guys do. Again, I'm writing all new questions because apparently you love watching my videos and you see what I asked last year, so I have to think of new things every year, which is fine. Every time I teach classes, different things come to mind. I don't ever look at the same things twice. So here's your question. Okay, the Constitution authorizes the president to remove, that should be removed, sorry. Okay. Remove principal officers. Go away. It's actually an NPR station. I'll get back to them later. Okay. So that's your question. The Constitution authorizes the president to remove principal officers. Another 10 seconds or so. Try to guess through. right, I'll stop it there. All right, now this question is difficult because it's a little bit involved, right? Who's, where did I drop off last time? Taylor, you're next. Okay, Taylor, what's your thinking here?
I'm going to go with false.
Okay, tell me why you think the answer is false.
Because there's, like, the very same article created that the president can remove principal officers.
Uh-huh. What does it say? So what do we know for sure, right? What does Article 2 say? Well, let's also ask you the question like that, Taylor. Okay, good. So we could Article 3, Section 2, and it actually says the President shall nominate and by and with the advice and consent of the Senate shall appoint, as Taylor said, ambassadors, ministers, consuls, etc. Right? There's no question the president can appoint. And there's a process he has to go through to get people on the bench or get people in the executive branch, etc. But, Amber, my question, which am I going? Yeah, you're next. Okay, Amber. Amber, my question for you is, does the Constitution provide a path for the president to remove these principal officers?
No.
Okay. So, on one hand, you're correct, right? There's no specific reference in the Constitution to the removal power. But Amber, do we stop there, right? If the framers didn't include a specific power for the president, does that mean he lacks that power?
No.
How do you know that?
Because the president can get powers from either the Constitution or from Congress. So.
Good, very good. Okay, just finish it up. So, but does the Constitution have to enumerate or spell out all the president's specific powers?
No.
Okay, very good. Juliana, you next? So, Juliana, how do we know that the president might have some powers that aren't expressly listed and enumerated? Where do we know that from? I'm just on the Constitution now. Precedent comes later, right? We'll get to precedent in a minute. How do we know that the president has some powers that aren't expressly enumerated? Where do we know this from, the Constitution? Well, it says the president can, appoint judges and appoint ambassadors, but there's a specific provision I'm thinking of, Juliana.
The appointment clause?
No, not the appointments clause. Very specific provision of the Constitution, Article 2. Very beginning. No, you're far down. A little bit earlier. Very beginning. Actually, you know what it is? What's the very first sentence in Article 2? Very first sentence.
The executive power shall be vested in the President of the executive powers to appoint, or to, I guess, have someone acquire them.
Well, isn't that the question, though, right? So first you said exactly correct. Unlike Congress, which has only enumerated powers, the president, the executive, has also powers that are not expressly enumerated. This is the executive power, whatever that is. And it's vested, right? It's installed in the President of the United States. So the mere fact that it doesn't say the president can fire an official, an officer, doesn't mean he lacks that power, right? Unlike with Congress, unless it's written in the Constitution, they don't have it. Easy. But with the president's not so clear. So then, Sophia, the question is this. How can we know from the Constitution whether the president has this removal power? Where can we get this power from if it's not expressly listed?
I think
the take care clause. What does that say?
we shall take care that the
Okay, so this is Article 2, Section 3. Sophia's exactly right. We looked at the take care clause. And it says the president shall take care that the laws are faithfully executed. Sophia, how does that get us to a removal power? It just says take care laws are executed. Why does that tell us the president can fire people? Where does that come from?
Because his power to appoint also has an incidental power, I think, to remove them because a lot of his powers rest on his insubordinates doing what he tells them to do.
So what happens, Sophia, I'll just finish up with this question. If the president has, say, Secretary of War or Secretary of State who's doing bad stuff and doing stuff the president doesn't like, can the president take care that the laws are faithfully executed if these people are engaging in insubordination and screwing up his agenda?
Yeah, I think so. If they conflict with his...
If they conflict, can the president execute the laws faithfully if they're conflicting with his mission?
Yeah.
So what then can the president do?
Remove them.
Bingo. And that's the answer, right? The courts recognize that it's the take care clause that implies, and I like what you said incidental, which I think is a good explanation. The take care clause implies the removal power, right? So the question, the way I framed it, of course, is always tricky, right? But the Constitution absolutely authorizes removal. And we have to, whoa, wow, I think that's the closest one all year. Is that right? God, that's a good question. So I'll agree, this one's close, right? This is a close one. I think the better answer is it does authorize it, okay? And you have to look to the take care clause, I think for the reason Sophia mentioned. And if you look at Morrison, which is the first case we'll cite today, they expressly cite the take care clause as the basis of the removal power. Because think about it this way, right? Let's say the president appoints, Joe Smith to be Secretary of State. And then Joe Smith is an absolute jerk. And he basically ignores the president and doesn't do what he wants and starts negotiating rogue treaties, right? And making all these foreign arrangements with the president. What are you doing? He's like, you appointed me, I have this position for life. You can't fire me, right? That would be nuts, right? That can't possibly be the way our republic functions. Because the power of the executive is unitary, and he has the responsibility to take care that the laws are faithfully executed. And if his subordinates, his inferiors, are getting in the way of that, he can then can them and fire them. Right? So I think everyone agrees as a basic matter that the president has this removal power. The difficulty arises, though, what happens when Congress tries to limit that removal power, right? And that's the basis for our first case today, Morrison against Olson. What happens if Congress creates an office and puts strings on the president's ability to remove that officer? Now again, Morrison also put 1987, 88. It's a fairly recent case. I mean, recent, you guys probably weren't born yet, but it's a fairly recent case. But this has been an issue that has plagued the Republic since the very beginning. The very beginning. And the question is this: can Congress put restrictions on the power of removal? And let me give you some brief history here, which isn't in your book, but I'll walk you through it anyway. In the very first Congress, there was a big debate, right? So, Laura, what's the process by which the president can nominate an officer? What's the general process? Walk me through it. It's spelled out right in the Constitution. Very easy to go through.
So, there has to be an attorney general.
Okay.
And
No, I'm not talking about Morrison. Just in general, what's the way the president can appoint an officer? Just in general, forgetting Morrison v. Olson. Okay, so the president makes a nomination. Then what happens?
And then they have to be approved by the Senate.
Right, majority vote, right? And then is it done after that point?
Yes.
Yeah. Well, actually, so here's the trick. We've done a case in this already. I didn't realize it. Laura, what case did we do very early on in the semester about the appointment process? Very early. Marbury. What was the final act after the Senate voted that had to be done in Marbury to make the commission final? See if you remember that.
It was the signing.
Exactly right, the signature, right? So Congress sets out the process by which a person can be appointed. Right? The Constitution says there's a nomination, the Senate gives its advice and consent, and the president are appointed. And this bit established by law. No one ever gets that far down, but it's there. Right? What does it mean established by law? Congress can specify how the appointment process is finalized. In that case, you have to have the signature and the seal of the United States. Okay? That's easy. That's not hard. But in the very first Congress, there was a debate. Did the president need Senate approval to fire someone? Some members of the House of Representatives said, aha, you need the Senate to approve the appointment. You also need the Senate's consent to fire. Did it? Did it not? This actually came up for a vote in the Senate, right? Whether you needed Senate approval to fire someone. And the vote tied. And what happens when there's a tie vote in the Senate? Vice President John Adams cast probably the only important vote of his entire administration as VP. And he voted, no, George Washington does not need your damn permission to fire someone. But that let the issue linger. It didn't get really resolved. When did it actually get brought up? During the Civil War. We haven't gotten to the Civil War yet, but you're going to notice a lot of the major changes in constitutional law occurred during the Civil War. So here's what happened. President Lincoln was assassinated. His vice president, a guy by the name of Johnson, became president. Johnson wanted to fire the Secretary of War. This was a holdover Secretary of War. Why? Johnson was a Southern sympathizer. He did not want to have a very strong Reconstruction process. He wanted to bring the South back into the fold. The Secretary of War, a guy named Stanton, was a Lincoln Republican, and he wanted to make the South suffer and go through Reconstruction and change their manners. So this is actually an insane story. Johnson told Stanton, "You're fired." What did Stanton say? "No, I'm not." The Senate passed a law which said you need the Senate to approve of termination. That unless the Senate approves of the termination, you can't fire me. And there was this dramatic standoff. I'm not exaggerating. The guy, Secretary of War Stanton, locked himself in his room, basically said, "Come and take me," right? Like, come and arrest me. Right, this is like with Tawney and sending the poor little marshal to arrest the general, right? It's like, okay, you want to fire me? Come and take me. This was a very dramatic moment. Now, eventually, he left office, right? Eventually, they resolved it. But the Senate and House tried to impeach the president. And what did they impeach him on? For removing Stanton without permission, right? They said, you violate the Constitution. The Constitution requires Senate consent to remove an officer. This is a big charge, right? We're used to constitutional questions being resolved in courts. But here you had a constitutional question being resolved in an impeachment trial. Now, as history reveals, Johnson was impeached in the House. Was he removed from office? No. One vote. One vote shy of removal. So in my mind, at least, that represents a judgment on the question, that the Constitution does not require this. But it didn't resolve the question cleanly. Until the 1920s, you had a case called United States versus Myers. This was referenced in your reading. I'm summarizing a lot of stuff for you. You're welcome. These are long cases. So the other case was United States versus Myers. In that case, the president wanted to fire a member of the Postal Service. Right? Want to fire him. The letter carriers, I think he was a postmaster. The postmaster said, no, you can't fire me unless you get Senate permission. Right? The same thing that the Secretary of War said. You need, for my office, Senate permission to fire me. This went to the Supreme Court. the Supreme Court ruled in favor of the president. The opinion was by Chief Justice Taft, who himself was the president. And they said the president has the absolute power of removal. The absolute power of removal without any question. In other words, President Johnson was correct. He could fire the Secretary of War. He did not need the Senate's permission. The Senate could not put strings on the removal power. Okay? So Myers was a blanket endorsement of executive power, this power to remove, without any qualifications. Myers would remain the law for a fairly short period of time, until about, 15, 14 years later with Humphrey's executor, right, which is referenced in your reading, but I'll discuss it as well. In the early 1900s, Congress began creating these agencies that were called independent agencies. Why do I give little scare quotes on independent? Traditionally, when Congress created a department, the Department of State or the Department of War, it was headed by a single person who was accountable to the president. The president appointed that person at will and could fire that person at will, right? This department was just an extension of the executive's own power. But these new agencies were deemed independent. And what does that mean? Instead of being headed by a single person, they were headed by boards of 5 people. 3 people appointed by the president's party, and 2 people appointed by the opposite party. So if President Roosevelt was in office, it would be 3 Democrat appointments and 2 Republican appointments. How do you know if something is a board or commission? As 5 members, right? If you see something that's 5 members, like the Federal Trade Commission, Federal Communications Commissions, the Securities and Exchange Commissions, go down the list. If the word commission is in there, it ends in a C, it's an independent board. That's the rule of thumb. Now, when President Roosevelt came into power, he had a different vision. He didn't very much like these independent agencies. He didn't very much like them. And there was one guy he really didn't like, named William Humphreys. Humphreys was a commissioner on the Federal Trade Commission. And he said to Mr. Humphrey, it'd be really good if you quit, right? It'd be really good if you quit, even though you had a 5-year term. And I could put someone else more to my liking. And Humphrey said, screw off, no way, I'm not resigning. So then Roosevelt fired him. No. Roosevelt did not say, I'm firing you because you did a bad job. He didn't say, I'm firing you because you're lazy. He said, I just want to go in a different direction, right? I want my own guy in there who can do stuff differently. That's all Roosevelt said. So Humphreys actually filed suit. He sued for his salary, right? He says, I was due a salary for 5 years. I only got it for 3 years, whatever it was. Now, why is the case called Humphrey's executor? Anyone know? Yeah.
He died.
He died, right. So in the middle of the litigation, Humphrey died. He died in the middle of the litigation. So his estate continued on suing for his back pay. Now, this is funny. A couple years ago, I made an offhand comment, yeah, but Roosevelt had him killed. I was just joking. It wasn't serious, right? But people watch my lectures. And there was a guy, he's actually in Virginia, said, I'm going to look into it. I was like, hey, you go do that. He actually got from me a copy of the death certificate of William Humphrey, which I have in my office. If you want to come see it, I'll show it to you later. He died of arterial sclerosis. He basically had a heart attack, right? There was no foul play. It was a completely routine certificate of death, right? This wasn't like, Roosevelt had the guy offed. There's not, not like a Vince Foster, right? There's none of that stuff. The guy died in the normal course. But he died. But his estate, his executor, continued suing. So the question here is, could Congress create these independent agencies? Now again, less than 15 years earlier, in the Myers case, the court held the president has the absolute removal power. But here the court reversed its trajectory. And they said, no. FDR, you can't remove Mr. Humphrey. You can't remove him, right? Why? Here's an important point. This is not an executive branch agency. It's independent, the court says. It has some judicial powers. It has some legislative powers. That is, it's quasi-judicial and quasi-legislative. it's not purely executive. And because it's not a purely executive agency, the president doesn't have the unfettered power to remove the officers. That is, Congress can put strings, conditions on removal. Humphrey can be removed for, inefficiency, neglect, malfeasance in office, but not a mere policy disagreement, right? Roosevelt can't just say, I want something else in that office. So this was a big case. Now, was Humphrey's executor correctly decided? Probably not. Most scholars view this decision as a retaliation against Roosevelt, that this guy was pushing, this is before 36, by the way, or it's right on the cusp. They saw this as pushing against Roosevelt, saying, look, you're going too far, you're trying to do too much stuff. It was reactionary. I think Scalia has a line in his dissent about this activist court. Probably right about that. But Roosevelt's opinion, the Humphrey opinion became settled law, that Congress can put certain strings on the removal power, right? They can say you can only be fired for neglect or malfeasance in office, all right? That's the background of Humphrey, and that brings us up to Morrison and the Nixon stuff. I just summarized probably 80 pages of reading for you. I used to assign those cases. I don't do it anymore because they're really long. The Myers opinion is like 100, only 200 pages long. It's trim, but it's long. It's a long. Chief Justice Taft was, again, the former president. He really cared about this issue. He had this long opinion, which I think was completely right. The Humphrey's opinion is much less interesting. He says, yeah, we didn't really mean what we said. We got this other stuff. All right. Questions on Humphreys or Morrison? Yeah, Kevin.
Does this apply to removing his military command as well? Because kind of backtracking it, before in the Civil War, didn't Lincoln fire 3 generals? And then Congress then passes the law saying you can't do what Lincoln basically did.
I'm not familiar with the generals you're referring to, but as a general matter, right? As a general matter, the president can remove military officers to the chain of command. That is, if the general reports him, the president can fire him. But if it's someone below, the person below him has to fire him the chain of command. It's actually an open question. Could the president fire by himself, a corporal, right, a line guy? It's never done before. Usually the president would say, you fire him. But whether the president can do it directly, I think is a good question. Not a clear answer. Yes, Damon?
Can we just summarize the takeaway from the Humphrey court was the president can remove the pure executive officials, but not the quasi one.
Well, it's not that he can remove it. If Congress creates this quasi-judicial, quasi-legislative agency, they can put strings on the removal power, right? So what is an agency? Let me explain that, right? The Federal Trade Commission, they do lots of things. So for one, they issue regulations. Now, what's a regulation? Everyone probably asks yourself that question. A regulation is basically a rule that's never voted on by Congress, right? They publish it in a book, and it's binding on people. But it's not voted on by Congress. The president doesn't approve it. So they have this what's called quasi-legislative function. It looks a lot like laws, but it's not. They also have courts. These are not Article 3 courts, but they're Article 2 courts, right? Within the agency, they have people, they call themselves judges. I don't call them a judge, but they call themselves a judge. And they hear cases. They even wear robes sometimes. So they have some sort of judicial function, and then some sort of legislative function. They also have an executive function, right? So let's say you start, engaging in anti-competitive behavior. FTC can go after you and enforce it and say, no, you can't do that. Let's say you pollute in a stream, right? The EPA can go after you and say, no, I'm going to fine you for that. So it's like these little quasi-governments themselves, these agencies. They don't fit anywhere in our 3 branches. Justice Jackson called this headless fourth branch of government, which is a good phrase. They don't exist anywhere. But the key aspect of the independent agencies is removal. The president can't fire their heads at will. He can only fire them for specific reasons that Congress specifies. And the rule in Humphreys, to answer Damon's question, is if it's this quasi-judicial, quasi-legislative agency, Congress can't put those strings on the removal power. If it's a purely executive agency, State Department, Attorney General, right, Secretary of War, that you can remove on the fly. You can't restrict it. Make sense? Okay, so then the question then is, what additional types of strings can Congress put on the removal power? That is, which offices can fall into this quasi-legislative or quasi-judicial category? Now, I'll give you the answer. This quasi-legislative, quasi-judicial test, the Supreme Court overturns it, right? This is why I don't teach a case anymore, right? All this buildup with Humphrey's executive, is it quasi-legislative, is it purely executive, what is it? The court basically throws that away in Morrison. All right, everyone with me? Okay, let's do some more history. This is very relevant for the world we find ourselves in. Last year, when it was in January, when President Trump fired Sally Yates, I had all these reports calling me, Josh, isn't it like the Saturday Night Massacre? And I said, well, Nixon didn't fire anyone during the Saturday Night Massacre. Like, what do you mean? I can't tell you how many law professors screwed this up and say Nixon fired these people. He didn't. He instructed others to do it. And I was correcting all these people at much higher institutions than me. Anyway, you guys get the real steal, right? History, it's actually really funny. I had taught this case like a day before Yates was fired, so it was fresh in my mind. So I just taught it. So teaching matters. All right. This is a very complicated thing, which, right?
So I understand what you're saying, that Nixon did not actually terminate or Yates. But in the case of Nixon ordered subordinates to do this.
I'm going to get the story. I'm going to do the story. Yeah.
Okay.
Yeah. You want to steal my thunder more, or are you good? No. But there's a big difference, right? This is the question actually Kevin asked. Could the president fire a corporal, a line guy down? But there's a chain which Nixon actually respected, believe it or not. Okay, let me give you the story. Then, if I don't answer your question, you can hit me on it again. Okay. Anyway, so in 1972, the Committee for the Re-election of the President, acronym CREEP, which is a terrible acronym, hired burglars to break into the Watergate Hotel. Why the Watergate Hotel? The Democrats kept their headquarters there, and what they were looking for, still not exactly sure. To this day, we don't actually know. I mean, with all the books, we don't really know. We do know that the Nixon campaign offered to pay the burglars to keep them quiet about their break-in. Now, this was before Twitter, before the internet. This story didn't break till after the election in '72, after Nixon won in a landslide. Today, this thing would have broken in 5 seconds. Some guy like live streaming it, right? Didn't break. As is often the case, the cover-up is worse than the crime. And impeachment proceedings began in the House in '74. Now, Nixon, recognizing that someone was up, appointed a special counsel. Again, a special counsel is not independent counsel. Alexa Morrison was the independent counsel, right? This has all these protections from firing. Here we're talking about a special counsel. Robert Mueller, for example, the current investigation, is a special counsel. Okay. The first counsel is a guy named Archibald Cox, who was a law professor from Harvard, which is never why you let law professors have any power. It's a bad idea. Cox learned of a secret tape recording system in the White House. And he issued a subpoena to the White House to release the recordings, right? This is what triggered the so-called Saturday evening massacre. It happened on Saturday night in 1973. This is a front page headline for the New York Times. Okay, again, Nixon discharges Cox. Not exactly, so let's walk through what happened. Nixon ordered his attorney general to fire Cox. The AG was a guy named Elliot Richardson. Richardson refused to fire him. Now, here's the point. Why did Richardson refuse to fire him? Because he had promised the Senate during his confirmation hearing, I will let this process go forward. So there was no problem with him firing it. He said, I promised the Senate, I'm going to do it. So Richardson resigned. Okay? And the way it works is the second in command gets elevated. So the deputy attorney general, a guy named Ruckelshaus, was elevated to attorney general as acting. He too refused to fire the special prosecutor, the special counsel, Cox. At that point, the third in line Robert Bork, who was the Solicitor General of the United States. The Solicitor General argues for the Supreme Court, was elevated to acting Attorney General. He then fired Cox. Now, this seems like a very dramatic thing, like, oh, one got fired after the other. They knew this was coming, right? And in fact, Richardson actually told Bork, Bob, you have to fire him, right? Why? A.G. Richardson had promised the Senate he'll let this investigation go forward. The deputy A.G. Ruckelshaus said, I promise I'll let this go forward. Bork hadn't made that promise. So Bork was the guy who actually could do it. Again, so it's like this dramatic scene, but it was actually rehearsed, right? Bork and Richardson said in advance, here's what's going to happen. I'm going to resign. This guy's going to resign. You fire him. Okay. Like they understood it, but it was still massively controversial, right? Bork said he understood that this was a valid order, but he didn't want to be perceived as being the man who did the president's bidding to save my job. There's a funny story. So after Bork was appointed as the acting attorney general, he refused to actually accept the prestige of the job. So at the time, Bork had this old beat-up Volvo, a 4-cylinder car. And it was in such bad shape, he couldn't even drive up the ramp into the garage, right? It was a very steep ramp going up to the DOJ garage. He couldn't drive it. And the AG gets a private town car, right? He refused to take it. Like, he did not want this job. So he would drive around his beat-up old car. He kept his old office. It's a good story. But, and there's always a lesson for history, when you fire one special counsel, another one will be appointed, which is why this Mueller stuff is so stupid. He's not going to be fired because someone will be appointed in 5 minutes. Anyway, after Cox was fired, another special counsel was named Leon Jaworski. Yeah.
Could they have just put Cox back?
As Attorney General?
Yeah.
Well, once you resign, you're out. You have to
Cox.
read the same guy?
Yeah.
Oh, I guess they could have. Right? They could have, but the decision to fire Cox was probably Nixon's undoing, right? This decision to have him ordered to be removed, that probably accelerated it, but he was toast anyway at this point. I mean, you get desperate at this point. So Nixon resigned. I'm sorry, I skipped a step. Jaworski was hired. They did more investigations. Eventually, the Supreme Court ordered that Nixon had to turn over the tapes, right? That he had to put over the White House tapes. And once the tapes were turned over, it became clear he was aware of the break-in. Exactly what he knew, we don't know exactly, but he was aware of the general break-in and aware of the cover-up. He knew about it. It was on the tapes. Nixon resigned then in August of 1974. He was the first president to step down in office. Hadn't happened before. The iconic photo where he's getting the helicopter like this, and then he steps down. Very, very dramatic moment in American history. But the consequence of Watergate, that's what the scandal is called. Everything's gate, right? Yeah, Watergate, sex gate, this gate, that gate, right? Showergate. These are all gates, right? But the aftermath of Watergate, don't Google it. The aftermath of Watergate is that Congress took specific actions, and they sought to enact the 1978 Ethics in Government Act, this EIGA. And it created this office of the independent prosecutor. Again, not special counsel. It's called the independent prosecutor, independent counsel. The key word there is independent, the I, right? That's the key word. Okay? And this independent counsel statute was enacted with a sunset provision that unless Congress reenacts it every so often, it fades away into the sunset. So it was in effect in the 1970s, late 70s, early 80s, and 1990s. It expired in 1999 or 2000. And the reason why it expired is because of the experiences with it, that this was an absolute disaster. That having this unchecked independent prosecutor who can dig wherever he wanted was a mistake. And the experience with Ken Starr, who went after Bill Clinton, we'll get through in a bit, told people this was a mistake. But it was upheld in a case decided by the Supreme Court by a vote of 7-1. Okay? That case is Morrison against Olson. Okay? Trey, did I get what you wanted?
I'll talk to you guys about it.
Okay, that's fine. That's fine. All All right, so any question in that background? I'm lecturing quite a bit, but I promise there's participation at some point. All right, Chaz, give me the facts in Morrison.
So Congress passed the Ethics in Government Act of 1978.
Good.
And that act permitted a court, a special division, to appoint independent counsel to investigate high-ranked officials.
Okay, good.
Also, the independent counsel that they could end the position whenever the investigation or case prosecution was complete.
Mm-hmm.
So Morrison was the one that was appointed to investigate.
Okay, that's good. That's good. So I want to just focus before we get to Morrison. I want to focus on the actual statute. Okay. In the general course, right, the general matter, if there's suspicion of a crime, the Attorney General can make the choice of whether to investigate it or maybe not to. And that's a very important decision of whether to prosecute someone. Now, maybe they might decide the evidence is flimsy. Maybe they might decide that the resources are better spent elsewhere. Maybe they might decide that we want to focus our priorities on other crimes. And maybe they might decide, we really like this guy. He's important for our country. It'd be a damn shame if he went to jail. Let's not prosecute him. There are lots of reasons why the federal government might decide to prosecute someone or not to prosecute someone. Right? There are a lot of reasons. What the Ethics in Government Act does is it short circuits that process, and it creates a very specific pipeline between an allegation and the appointment of this independent counsel. So Arlene, can you just walk me through what's the process by which this IC, the independent counsel, can be designated?
So I think if I have this right,
Okay.
Congress will ask the Attorney General to conduct an investigation.
Good.
Then he conducts an investigation.
Good.
And then he has to report everything to the special division.
Right. There's a group of judges, right? Very good.
And then from there, he tells them if he has to apply to the court for an appointment for an independent.
Oh, so he can apply for an appointment, but what if he decides he doesn't want to apply for it? What must the AG do?
If he wants to apply for it.
If he doesn't think it, but what must he do?
He has to find sufficient grounds.
Okay, exactly. So the Attorney General has to decide, here's the key phrase, that there's, quote, no reasonable grounds to believe further investigation is warranted. Right? So after his initial investigation at 90 days, he has to report to this court. He has to say, Your Honors, there is no reasonable ground to believe that further investigations are warranted. He has to certify that. Right? Lauren, is that very vague? No reasonable grounds? Is there almost always going to be some reasonable ground to continue investigation?
I think so.
So what's the consequence of this, right? In almost every case, what is the Attorney General going to have to do? No, not just he investigates. What will have to happen in almost every case?
He would have to give the grounds.
And if there are sufficient grounds, what happens next?
He would have to apply
For
for.
You're almost there. What does he have to apply for? If he finds that there are sufficient grounds to investigate further, what must he apply for?
The special independent.
Exactly, right. If the AG finds that there's reasonable grounds to investigate further, he has to ask this court, the special division, to appoint an independent counsel. Again, in the normal order, if the AG decides, there's probably grounds to investigate, but this is not a good use of our time, or it's not a good use of resources, or I really like that guy, right? That's the end of the story. But here, he's required to, right? He's required to apply to this court for the appointment of the independent counsel. Okay? Everyone with me so far? Everyone with me so far? Okay. after he makes his determination, the special division, the judges, appoint the special counsel. Now, Stephanie, how in our constitutional system can judges make an appointment? How does that even, is that even allowed?
Well, I guess.
Well, not you guess so. Where does the Constitution allow this to happen? Does it allow it to happen? Stephanie, what are the modes by which a person can be appointed?
He gets nominated by the president.
Is that the only way a person can be appointed to an office? Look at the appointments clause, right? Read the last part out loud, please.
But the Congress may, by law,
Sorry, scroll too far.
possess the appointment of such inferior officers as they think proper in the presidential
Alone?
in the courts of law or in the
Oh. So there's an alternate path by which officers can be appointed. If the officer is inferior, he can be appointed by the president alone, the heads of departments, or the courts of law. Now, the heads of departments common, right? If any of you have ever worked for the federal government, you got hired by someone who wasn't the president, I'm pretty sure. Maybe you were, I don't know, but the person who hired you was probably head of department. And they can appoint you, you're inferior. Doesn't mean you're stupid or bad, just means you're low on the totem pole, right? You're low on the ladder. Same for the courts, right? If any of you want to clerk for a federal judge, you're going to be hired by the judge, and you're an inferior officer. So in theory, at least, the Congress can tell the courts to make this appointment. But that begs the question, is Morrison, is the independent counsel, Stephanie, what kind of officer?
inferior.
Bingo, right? If she's inferior, that's fine. It fits within this rubric. If she's a principal officer, it can't be vested in the courts of law, right? So that's one of the questions. Let's go back to the appointment process. So the AG makes this application to the court. The judges then appoint the independent counsel, and it's the courts that define the counsel's jurisdiction. Now, usually when a court of law makes an appointment, it appoints someone who works in the judicial branch. And if the head of a department makes an appointment, someone who works in the executive branch. But can you have this inter-branch appointment where a court is appointing a prosecutor in the executive branch? Can you have that cross-contamination? It's another issue to consider. Okay? So once appointed, the IC, the independent counsel, has the full power to investigate all investigative and prosecutorial functions of the Attorney General. Right? They can convene a grand jury. They can seek an indictment. They can even file appeals. So it's like a little junior varsity Attorney General. They can do basically everything they want. Okay? Within the jurisdiction they're given. Now, that jurisdiction often expands. Right? With Bill Clinton, the Watergate investigation began with some land deals that Bill and Hillary Clinton had and expanded to sex with interns, right? These things expand very quickly. It's very hard for these counsels to keep their stuff in a line. Now, here's the key point, right? Donnie, how can the IC, the independent counsel, be removed from office? This is the biggie. How can the IC be removed from office?
If I believe they could be removed from office if they are here to be executive.
What must happen for the IC to be removed? There's a process. It's a specific process spelled out in the statute. Well, they can be impeached. That's certainly true. What's the other route for removal? How? What does the Attorney General must do to remove the IC? What must he show?
He made sure that they, like, there was for a good cause.
Good. Yeah, keep going. Good cause. What else?
Physical disability, mental incapacity, or any other condition that essentially affects performance.
Very good. So the statute specifies that the IC, the independent counsel, can remove only for good cause. And it lists a few: physical disability, mental capacity, or other condition that impairs the performance of such duties. Shara, can the Attorney General fire the independent counsel because he doesn't like her, thinks she's doing a bad job, thinks that her resources should be put elsewhere, and say, you know what, go away? Can the AG fire him or her for that? Exactly right. Okay. The purpose of this protection is to prevent what happened to poor Mr. Myers, right? It's to prevent the IC from being tossed out by the president. Because imagine if the counsel is investigating the president. Imagine that, right? And the president says, I want this person fired. And that will just end the prosecution. This was a direct reaction to the Nixon Watergate scandal. Okay? So the AG can remove the IC. The Attorney General can remove the independent counsel only for cause, good cause, right? Not merely because they disagree with them. All right, everyone with me? So what happened, right? So the actual facts of the case are this. An independent counsel was formed to investigate this guy, Ted Olson. At the time, Ted Olson was working in the Reagan Justice Department, and he gave some legal advice about a EPA matter, Environmental Protection Agency. This involves the so-called Superfund, which is this massive toxic waste dump, whatever, right? At the time, fun fact, the head of the EPA was Anne Burford Gorsuch. Yes, the mother of Justice Neil Gorsuch, right? Eventually, his mother had to resign in some disgrace because she was involved in a little bit of a scandal. But Olson didn't, and they went after Olson for giving bad advice to the government. And Alexa Morrison was appointed as the IC, the independent counsel, to investigate whether Olson was violating federal laws. Olson challenged Morrison's appointment. He said, you can't investigate me. You can't issue me the subpoena because your appointment is unconstitutional. Right? Because your appointment is unconstitutional. This is actually one of the rare cases, Morrison versus Olson, where Morrison argued at the Supreme Court and Olson argued at the Supreme Court. They argue their own cases. It doesn't happen very often. Right? It's very rare. But Morrison was a lawyer. She argued her own case. As Lincoln would say, a person who argues for himself is a fool for a client. But they did pretty well, I think. All right, so there are three issues, right? Hannah, what are the three issues that the court, Justice Rehnquist's opinion, has to confront? The three major questions.
The first is whether she's inferior.
Very good. So the first question, right? Is she in fact inferior? Again, going back to the text of the Constitution, the judges, the courts of law can appoint inferior officers. So is she inferior? Okay, Hannah, what's the second issue?
Whether Congress can appoint equal branch appointments.
Okay, right. So the second question is this, right? Even assuming that she's an inferior officer, can Congress let a court appoint an executive branch official? Okay, what's the other questions?
I believe the last question is whether this violates like the idea of separation.
Very good. And the general, and this is a third question, a little bit nebulous, right? Does this violate the separation of powers? Does giving so much authority to this position that the president can't remove her for any good reason, any reason at all, does that infringe on the separation of powers? So we're going to get the general gist, right? The first two issues are fairly technical. Is it inferior? Is it interbranch? But the biggie is, this is where Scalia focuses his dissent. Does it violate the separation of powers? All right, Derek, so is Ms. Morrison an inferior officer according to the majority?
Yes.
Okay, good. Tell me why.
Because she can be removed by a higher executive above her, and she has limited jurisdiction, and her office is limited in tenure.
Okay, very good. Okay. So the first part of the answer, Donnie's exactly right. The court says that she's clearly inferior. By the way, when you see an opinion that uses the word clearly, it means they have no argument. Never use the word clearly in your writing because it means you have no argument. If you had an argument, you'd say instead of saying clearly. I hate that word. Don't use clearly. It's a pet peeve. It's like, oh, of course, clearly. If it was so obvious, it wouldn't be in court, right? If it was that obvious, it wouldn't be at the Supreme Court. Yeah, Abdul. Yeah. If you want to make the argument, make the damn argument. Yeah. I agree. It depends who you ask. Yeah. Well, the phrase self-evident, though, actually refers to a body of natural law scholarship, to be precise. There was a lot of things about self-evident truth. That wasn't like a phrase they made up, right? But clearly falls to inferior weak, right? So they give a couple reasons why it's clearly inferior. That he's subject to removal by the Attorney General, that his jurisdiction is limited by statute, and he can't do everything in the world, okay? So the court dismisses that one pretty quickly. I'll do the Scalia dissent later. Chase, what about this intra-branch appointment? Is there a problem that the courts are appointing someone in the with this sort of executive branch agency? What's the court's argument here?
The court's argument how all three branches have kind of power to the whole the way the process goes. That being the executive has the Attorney General to terminate, the judicial is the one kind of appointing with the help of the executive, and then Congress is the one that gets it started.
Okay, very good. And Chase, they look at the appointments clause, right? It says, the Congress may by law vest the appointments of such inferior officers as they think proper in the courts. What does that mean, as they think proper, Chase? What's the significance of that language? The court discusses this.
I'm not sure.
What does that mean, as they think proper? Who's they in this case?
It's referring to the inferior officer?
No, read the clause. Congress. What does this phrase proper mean elsewhere in the Constitution that we've seen, Chase?
When we talk about necessary proper, it means, I can't come up with the right words for it, but essentially it means like not the right thing, but...
How do courts review this phrase proper? What do they usually do when they say Congress has a power that's proper?
To not be unreasonable.
Yeah, flexible, right? So what the court says here, I think this argument is actually fairly strong, is the Constitution says Congress has the power to make these appointments and as they think proper. That implies there's discretion, right? That Congress has a choice of how to do this. So because there's something expressly barring this intra-branch appointment between the executive and the judicial, there's no problem with it, right? So far, so good, right? The first two parts of the court's opinion, we can quibble with, but they're not bad. Okay? The next part, though, the third part, the separation of powers, is where the court, I think, ultimately loses Scalia in a very big way. Jake, walk me through the final issue, the separation of powers business.
They basically said that since Congress doesn't appoint power in the judiciary and the removal authority and the Attorney General, Congress cannot usurp executive authority.
Right. So what about this business, though, right? In Humphrey's executor, Jake, with if it's quasi-judicial and quasi-legislative, what about this entire line of reasoning? What does the court do with Humphrey's executor here?
Oh, they basically overturn it.
Yeah, they overrule Humphrey's executor. Not expressly, but they say, well, this test about whether it's quasi-judicial and quasi-legislative, we're not going to follow that, right? They say, our present considered view. Don't you love that, right? Our present considered view means we don't agree with those dead guys 80 years ago, right? We're not, or I think it was 50 years ago then. We're not agreeing with those guys 50 years ago. Okay? They put forward this new test, right? When does a restriction on the removal power go too far? When the officer has power that's, quote, so central to the functioning of the executive branch. That's your new test. If the officer has a power that's central to the functioning of the executive branch, goes too far. The old test was, is it purely executive? And the new test is, it's so central to the functioning of the executive branch. Brian, what's the difference between purely executive and central to the functioning of the executive branch? What's the difference there?
I'm not really sure, but I guess it'd be something along the lines of like it's not incidental, or I don't know.
Well, let me ask you this one, Ryan. Would a prosecutor be purely executive in function? Would Alexa Morrison, the IC, right? Is she purely executive? Just talk to two of us.
No, but she does some kind of.
Well, no. Does she pass any rules? Does she put a robe on, act like the judge?
Yeah, she just does like investigative functions.
Yeah. So Alexa Morrison fits the old test, right? She's purely executive. But Ryan, finish it up. Is she central to the function of the executive branch? Just Alexa by herself. In other words, can the executive branch keep doing what it's doing even if she's off doing her wild goose chase? Yeah. And that's the difference, right? Even if Alexa Morrison is purely executive, she's not central to the functioning of the executive branch. Why? Because they can do their own thing, right? The executive branch keeps chugging along, and she does her little wild goose chase. You know, poor Ted Olson gets his reputation dragged to the mud, whatever, right? But this new test is a lot harder to satisfy. And unless the restriction concerns the central functioning of the executive branch, it's okay. So let me summarize this for you, right? The test, right? The test. Can Congress put a limitation on removal power? Yes, they can. When can't they? If the officer is central to the function of the executive branch. If it's a central function, Congress can't put strings. They can't put a good cause requirement. For all other officers that are not central, Congress can put a good cause standard on removal.
So you're saying that the test for being central is removing that person, the executive branch cannot operate.
I'm giving you my interpretation. The court doesn't tell you what that means, if you notice. If you my notes, I wrote meaningless test. That's where I wrote my notes, right? It's meaningless. I've actually written that something like, what does this mean, right? I've given this a lot of thought. Rehnquist doesn't give us anything. In fact, we'll probably have, by the fourth edition of the casebook, another case about this when someone tries to get fired. This will happen maybe next year or so, right? But this is going to come up. They don't tell you. But this phrase, so central to the function of the executive branch, in my mind, right? This is Josh talking. That means if you remove this person, like the thing would just fall apart, right? It's got to be really important. Like the Attorney General, for example, right? This person, if he's not there, the executive branch would fall apart. The Secretary of War, right? You know, or Defense. If you can't have someone prosecuting your wars, things would be really bad. But you know, poor little Alexa Morrison with her wild goose chase, whatever, against Ted Olson, whatever, things go on. Derek, I think I saw your hand also. Oh yeah, I'd be happy to. The test, right, is this officer exercising discretion that is so central to the functioning of the executive branch? If the answer to that question is yes, they must be removable at will, without any cause. Not a very good test. I think Scalia makes his point. At least purely executive had something you could go with, whatever that meant. This is just flub. It's not real. Now, if you notice, I've been really hard on Justice Rehnquist here, right? Chief Justice Rehnquist. Even though this case is 7-1, this is one of those rare cases where the dissent got it right. Solo dissent. And Scalia's dissent in this case is considered iconic. It's famous. I actually love reading his opinion so much. Every time I read it, I get very happy. Because he's such a good writer when he's by himself. He doesn't have to appease anyone else. And he can go, full Nino, right? Give you the full. His nickname was Nino, the full Nino treatment. And it's actually a great sadness of mine that I can't edit any more of his cases. That all the Scalia cases we have, they're fixed, right? There's no more. There's no more Scalia decisions. We lost a great writer. Even Justice Kagan, who probably couldn't stand his ruling, said this is one of the best dissents ever written. I think it's definitely in my top 10 for sure. So, all right, any questions to the majority, right? Again, what's your test? Congress can put limitations on an officer unless it's central to the functioning of the executive branch, whatever that means, right? That's your new test. Any other questions on the majority by Rehnquist? Well, by the way, Justice Kennedy did not participate. He had been nominated to the court right around this time. I think he was fairly new. He didn't sit on it, unfortunately. I would like to have seen where he wound up. All right, any questions to the majority? All right, let's do Scalia. Again, this is such a good opinion. I mean, most judges are awful writers. They're just terrible. Some are manageable, some are serviceable. Most of them are terrible. That's why you hate reading for class, because their writing is dreck. It's bad. Scalia, it's fun to read. He would often say he wrote his dissents not for his colleagues, but for law school case books. He said, I want my dissents to be in law school case books for generations to come, and indeed they will be. He's speaking to you all. He's not speaking to his colleagues. He already lost, right? He lost the case. He knew the vote, right? He wasn't going to persuade 8 of his colleagues to switch sides, right? That wasn't going to happen. He's writing for you, so you're welcome. Scalia begins his dissent by saying that we have a government of laws and not of men. And this is a phrase that people often repeat. They don't know where it's from. And it actually comes from the Massachusetts Constitution of 1780, drafted by John Adams. And it says, the judicial shall never exercise the legislative and executive powers, or either of them. To that end, it may be a government of laws, not of men. And Scalia traces the strong principle of the separation of powers, that you can't have the blending of the executive, the legislative, and the judicial. Right? Without a secure structure of separated powers, our Bill of Rights would be worthless. And Scalia makes his point, right? Lots of countries in the world have a Bill of Rights. They're worthless. You would often hold up the Soviet Union's Bill of Rights. It was a lovely Bill of Rights. You had rights to housing and rights to health care and rights to education, all these fantastic rights. It was a totalitarian dictatorship. And what Scalia tried to convey is what matters to protect freedom is actually structure, for ambition to counteract ambition. That merely these rights on paper are mere parchment barriers. Won't stop anyone from violating them. But it comes down to power. Let me read you this passage. This is what the suit is about. Power. The allocation of power among Congress, the President, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a, quote, gradual concentration of the several powers in the same department can effectively be resisted. Here comes the magic. Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to affect important change in the equilibrium of power is not immediately evident, and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. Put down my tombstone, right? Not a bad quote. What's Scalia saying here? Usually, the government tries to hide the fact from the breaking the separation of power. They try and shield it and clothe it and this and that, wolf in sheep's clothing. But this comes as it is. It's expressly saying what it's trying to do, which is to distort the traditional bound between the three branches. And Scalia eviscerates it. And if you notice, the majority doesn't even respond to him. They don't even mention him. This is a tell, right? If you guys play cards, right? If you got a very weak hand, you usually have a tell. When the majority opinion doesn't even reference a dissent, it means they have a weak hand. And they're not, they know if they try to engage Scalia, they're going to lose. So they ignore him. But there's a cost when the majority ignores a dissent. Everyone knows it. You know it, and you know it. And it's obvious when you make an argument to someone and they just ignore you. It's like, well, why aren't they replying? They don't have anything in response to say. And it's exactly what Rehnquist's opinion does. By failing to engage a dissent, they basically let Scalia have the last word. And I think, in my opinion, there are 5 votes today to give Scalia the final word of this one. This may come up very soon. Maybe not so much anymore, but at least I said that like a year ago. But I do think there are 5 votes to say Scalia got it right. Right? So the questions here are the same as above, right? Right? Is this position inferior? Can you have these intra-branch appointments? And does this deprive the president of his duty to faithfully execute the laws? Right? And he actually takes them backwards. He goes in a little bit of a different order. And one of my favorite quotes is this, right? The imposition of a good cause standard is like referring to shackles as an effective means of locomotion, right? Right? The fact that the president is limited, the court says that gives him discretion. Not so. Okay. Why do we have these separation of powers, he says? To protect individual liberty. This is a point which students often have a little bit of difficulty understanding. You might just look at this case in the abstract, as whatever. But there's a guy, and his name was Ted Olson, and basically his life was ruined for the better part of a decade because you had this person chasing after him without any accountability. And never forget that when you have these independent counsels, there are people who are probably innocent who are going to have their lives ruined. And the usual checks on the investigatory process that exist fall apart here. All right. I think, Clinton, you next?
Yeah,
Okay, Clinton. Why does Scalia say that this cannot be an inferior officer, Alexa Morrison?
First of all, I don't agree that Scalia got this wrong, or got this right, and so
That's okay.
I'm going to pitch it from my thing.
That's fine.
So I've been trying to make a case on why he's wrong. But,
Okay.
he says it's not an inferior officer because that's kind of what she said. It goes unchecked. I mean, she doesn't have any bounds or she can continue forward.
Okay. What about the fact that her jurisdiction is limited? Why does Scalia think that's not relevant, Clint?
Reading on what he was saying, really trying to make a case why I thought he was wrong.
See, you get yourself in trouble. Evan, why does Scalia think the fact that her jurisdiction is limited doesn't make her inferior?
Well, the jurisdiction, he talks about, well, the majority talks about that she has like a time limit until she works until her work is completed, but Scalia argues that every executive official works until their work is completed.
Right. So as a general matter, people work till they're done. The difference is she gets to decide when she's done, and no one else. This is why the independent counsel against Bill Clinton lasted almost 7 years or 6 years, right? This is why the Mueller investigation might go on for quite some time. They get to decide when to draw it to a close. Okay. As far as the intra-branch appointments, Scalia makes a remark that I think is actually pretty good. He says, do we think for a second, right, that if Congress started to say we're going to appoint like law clerks, right, that we're going to decide who staffs the judiciary, the judges would probably get very upset by that, but they're not too troubled. Okay. Scalia also notes that the court overrules Humphrey's executor without even telling us why. To Damon's question, right, what is this test? Scalia describes it, trust us, right? We'll tell you when you're breaking the law. That's not much comfort to people in the executive branch who want to know, are they acting lawfully? Trust us, right? This line is not clear or even rational. There are no lines at all. Okay? Yeah, Richard? There you go.
So, my problem with this, and I've been looking, and I looked last night, and I never could find an answer. What checks the president's power? How can the president be impeached if he can just say, hey, I'm going to fire everyone who's going to investigate me?
Well, Congress can investigate him, can't they?
So Congress can go in, so they have to appoint someone.
Congress has an investigatory power. That's what the impeachment process is. They have committees and hearings, and they have subpoena powers. And Congress can go through the investigatory power without having a special counsel.
Okay, so Scalia is not saying, okay, fair enough.
Right. But that's the point. Scalia actually does address this. There are other ways to go after a bad president without this independent counsel. Congress can investigate, and also the president can appoint his own special counsel, like with Nixon, right? Nixon did not have an independent counsel on the books. And here's the key point. If the president starts firing everyone, that's going to be very unpopular.
Yeah.
And it might lead to his resignation, as with Nixon. So, and here's the important point. There are ways to go after a corrupt president without having this constitutional aberration, this independent counsel. It can be done. President Johnson was impeached. There was no independent counsel. They held a trial, they had a hearing, right? They can do various things. Now, what I think Clint's getting at is that they don't have the sort of normal investigatory power with a grand jury and a judge and a court, but there are constitutional means to go about that. Okay? Good? All right. And Scalia explains this point. He says, how frightening it must be to have your own independent counsel staff with nothing else to do but investigate you till they deem it's no longer worthwhile, right? In other words, the only thing this office can do is investigate Ted Olson, right? And when your job is to investigate Olson, you're going to keep going and going and going. There's no logical stopping point. It's a very problematic structure. And in fact, the current investigation with Mueller and Trump is not brought under the independent counsel statute. It's brought under the special counsel, the same manner in which the Nixon administration had. So there's actually an ongoing question about whether the president could fire Mueller or whether he could order his subordinates to fire Mueller. I think he could. I think the restrictions are probably unconstitutional. I think Scalia got it right. But even if Scalia got it wrong, I think the regulations probably still don't stand. All right. Questions then on Morrison against Olson. All right. This new test, whether it's central to the executive branch, that's your test. If it's central, Congress can't put restrictions on it. If it's not, Congress can put for-cause restrictions on it and make the president not be able to fire the person. By the way, in 1999, basically everyone agreed we could let the IC statute expire, let it expire. In the last year, with Trump and almost everything else, people said, we need to bring it back, bring back the IC. I think that'd be a disaster, it'd be a mistake, but people don't learn from history, they forget. Evan?
You mentioned that nowadays, Scalia might get 5 votes on his dissent. Is that in the case that Mueller gets fired? Or
Maybe.
Okay, there's not like a case pending?
No, so there's another case. This is actually my final exam question last year, so I'll mention it. After the economic crisis 2008 and 2009, Congress established a new agency called the Consumer Finance Protection Bureau, CFPB. And they sought to make this agency independent, right? Now, they could have created it with a 5-member board, like usual, but instead they put a single head. So something novel, right? A really powerful agency with a single head who is only removable for cause, cannot be removed at will. And this is being litigated for years and years and years. And about a month ago, the D.C. Circuit Court of Appeals ruled en banc altogether that the CFPB is a valid structure. That case we appealed to the Supreme Court. And the question is this: can Congress create an independent agency with a single person with for-cause removal? One of the dissenting judges, Judge Brett Kavanaugh, said Scalia was right. He didn't say that, but he said Scalia was right, and you need to sever this for-cause restriction. That is, the president can remove this person at will. He was in dissent. The majority upheld it, citing Morrison and Humphreys as well. So probably by next year this time, the Supreme Court will have a case on its docket about whether Morrison was right or wrong. I don't know what they'll do. They would surprise me. I think they'll probably go with Scalia, but what do I know? Cameron? Did you have it?
Oh, no, it's true.
Yeah, Rieto.
I'm just wondering, has Scalia's dissent been cited in major cases?
Oh, yeah. If you read Judge Kavanaugh's dissent that I just mentioned a minute ago, it only cites Scalia, right? I actually wrote a piece on this. Like, he basically cites Scalia as if it was a majority opinion. A little strange, but I think he's swinging for the fences. He also wants to go to the Supreme Court, but he won't get there. Yeah, Kevin.
So just to recap, so the independent counsel is the law that falls under this provision of the ethics government act, but the special counsel is appointed by the president.
The special counsel is basically based on internal government DOJ regulations, right? It's appointed by the AG. It doesn't involve Congress. So, for example, when Rod Rosenstein, who's the deputy AG, appointed Mueller as a special counsel, he didn't need Congress's permission. He did it by himself. He chose him and he gave him his jurisdiction what to investigate. The big difference also, for those interested, between the independent counsel and the special counsel, the independent counsel can seek indictments by himself, right? Ken Starr considered indicting President Clinton. He didn't do it, but he considered it. Robert Mueller can't indict the president or anyone else with his own power. He lacks that power to do so. He would need the deputy AG to sign off on it, which will not happen. Right? Whether you can even indict the president is even a tougher question, but indict is subordinate, perhaps. So, for example, last week you saw that Mueller indicted all these Russian fake news bots, whatever, right? That was with the AG's consent. That wasn't unilateral. The AG knew about it. Other questions? Anything else on Morrison v. Olson? Oh yeah, in the back, yeah.
If that investigation is without the AG's approval signature, can that investigation or after this be taken to the House Judiciary?
Yes.
And then they can start the process?
Yes, and that's one aspect of the special counsel. Mueller has a choice; he's not required to. But if he deems this in the public interest, he can submit his report to Congress. And in theory, Congress can use that as a basis for an impeachment. Which again proves that you can go after a president without having this aberration as an independent counsel. Mueller doesn't have to make his report public, although I think he certainly will at this point. If it ever ends, who knows? These things have a habit of going on and on and on. Every time we update the casebook, it's a new thing. All right, anything else on Morrison? Okay, let's go to the second case, Noel Canning. And I'll give you a little spiel. I've given this talk before, so. Okay. Anyway, so, all right. The basis of the next case, National Labor Relations Board versus Noel Canning. By the way, Noel Canning is not a person named Noel. It was a canning company. They made soda. They made bottles, right? So it was Noel Canning. The basis of this case arose over gridlock in the executive branch concerning appointments on the National Labor Relations Board. This is one of those 5-member independent agencies, right? 5 members. You had 3 members who were appointed by the president's party, and you had 2 members appointed by the minority party. Now, historically, when the president wants to make a nomination, right, he makes a nomination and the Senate votes on it. But not always, right? So during the Bush administration, Democrats hatched up a plan to shut down the NLRB. They want to shut it down. How? If they blocked President Bush from making appointments, right, the board would fall below 5 members, right? They say, there are 5 seats, let's block Bush's appointments. And if you block the appointments, at one point they were down to 2 members. Now, the NLRB has a requirement for a quorum, that is, to conduct business, they need 3 members. What happens when they drop down to 2? Look how lonely they look, right? This hallway, right? What happens when they drop down to 2 members? They can no longer do any work. And the Supreme Court held that this effort to deprive them of the deprive them of a quorum worked, and their opinions were void. So again, during the Bush presidency, Democrats blocked members of the board. What happened later? During the Obama presidency, Republicans blocked Obama's nominees to the board. It was the exact same thing, mirror image, nothing ever changes, right? It's this, it's just this image. If you ever see a Jane Austen movie, and they all start dancing, right? And they clap and they'll switch sides and keep doing the same dance. It's exactly like that, right? See, nothing ever changes, everything's just mirror image. So during the Obama presidency, they blocked his nominee, Craig Becker. As a result, the board was dropped down to 3 members and was about to lose their quorum. So President Obama decided to try something else, which is a recess appointment. Now, we know from the Constitution, the recess appointment clause says The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. Aha. So the President said, I will make an appointment to this board, this NLRB, during a recess. Now, the Senate was controlled at the time by Democrats. So you think, wait a minute, Josh, if the Senate is controlled by Democrats, why can't they just take like a month-long vacation, right? And let Obama make whatever nominations he wants? Aha. The adjournment clause. This is the biggie. I think I don't have it here. The adjournment clause, a clause no one ever cares about because it's very important. Right? It says, neither house shall, without the consent of the other, adjourn for more than 3 days. What does that mean? The Senate was controlled by Democrats. The House was controlled by Republicans. So House Republicans said, no, Senate, you're not taking a month-long break. You can take up to 3 days, that's it. Under the provisions of the adjournment clause. So the reason why this entire crisis precipitated was because the House Republicans wouldn't let the Senate take a month-long vacation. So instead of taking off, after Christmas for a month, they said, okay, we only let 3 days at a time. So the Senate began to do what were called pro forma sessions. Actually, I have a video up here somewhere. A pro forma session, right? Okay, what's a pro forma session? Every 3 days, a member of the Senate would come in, usually from Virginia or D.C. He would gavel in, gavel out, and be done with it, right? So they held a small session every 3 days. Let me play this video for you. It's very short. This is the entire session on January 3rd. About a minute. If you blink, you'll miss it.
The Senate will come to order. Pursuant to the Constitution, the hour of 12 noon, January 3rd, having arrived, the Senate convenes the second session of the 112th Congress. The clerk will read a communication to the Senate.
Notice it's completely empty. No one's there.
Washington, D.C.,
Completely
January
empty.
3rd, 2012. To the Senate. Under provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Mark R. Warner, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Daniel K. Noel, President Pro Tempore.
Under the previous order, the Senate now stands adjourned until 11 a.m.
That's it. That's it. If you blink, you miss it, right? That's it. That's the entire thing, right? So again, why were they doing this silly little recess appointment thing? Because the House said you can't adjourn for more than 3 days. Okay? So again, they come in, he gavels, totally empty room, no one's there, right? And he gavels out, and that's it. And so here's the calendar, right? Obama says, look, they have the forma session on the 3rd and a pro forma session on the 6th. Aha! There's a 3-day gap between the two sessions. Obama made his recess appointment on the 4th, right? So the question is this: was it a valid recess appointment? Now, the president's lawyers in the Office of Legal Counsel made a couple arguments, right? The first argument they made was, well, it's not actually a 72-hour break. They said these little silly pro forma sessions, they don't count, right? They don't count. So actually, the Senate was on break for a month, right? These little 3-day doesn't matter. So they told the president, you can make these appointments. And President Obama nominated 3 members to the National Labor Relations Board, and they then had their 5-member quorum. This would be challenged. As soon as this board issued an adverse ruling against Noel Canning, which was a bottling company, they bottled Pepsi Cola, right? Noel Canning challenged it, saying, aha, 3 of the members that issued this decision were improperly appointed. This is not a valid judgment against us. And challenged it. The Court of Appeals ruled in favor of the Noel Canning Company. The government appealed to the U.S. Supreme Court. Okay. So, what am I up to? Jeffrey. So, what are the 3 major issues that the court has to confront here?
I'd have to confront whether it's actually a right application of the recess power, because if it's actually a recess.
Okay. Right at the beginning, he talks about them.
The scope of what the vacancies may happen during that time means,
Okay.
and third part is the operation of the length of a recess.
Okay. All right, so let me walk you through this carefully, right? There are three. This is the clause. Let me read it to you again. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. So there are three key words here. The vacancies that may happen and recess of the Senate. Right? The vacancies that may happen and recess of the Senate. Those are your three key words. The, what do you mean the? Right? If I say, Abdul, if I say the recess, how many recesses are there?
Something specific.
Okay.
One.
He's very good. Abdul says, when I say the recess, I mean one. Noel Canning argued that when the Constitution says there's the recess of the Senate, they mean a single recess. What does that mean? Go for it. You finish it up.
So basically, you're saying that it's always a dispute between what recess they're referring to, whether it's the one, like, so this 3-day thing doesn't count.
Well, no. That's actually the next question, right?
Between sessions.
Yeah, between. Very good. So there are two types of recesses, right? Very good. There's intra-session recess and intersession. Alan, what's the difference between intra-session, and intersession recess?
There's one short, like 3 days between sessions, and then those extended.
Well, what does intra and inter mean? Intranet, internet, what do these phrases mean?
Internal recess and intra is like external.
Okay, good. I think you're on the right track. An intra-session recess is a break within a session. An intersession recess is a break between sessions. So let me explain this. Each Congress meets for 2 years, right? When you're elected to Congress, you serve in 2 years. Each of those years is called a session, right? So if you were elected to Congress in November 2016, you served 2 years. The first session is from 2017 to 2018. And the second session is from 2018 to 2019, right? The intersession recess is the break between the first session and the second session. It's a period of time. Often it's only a couple seconds, right? But there is a break between one session and the other. There's one, right? There's one break between sessions. An intra-session is a break within a session. Well, if you go home for lunch, right? Take a lunch break. Take off for Christmas, right? Take off for President's Day, whatever it is. It's within a given session you take a break. There are many breaks within a session, right? Every time they go home for the night, it's an intra-session break. Okay? So the first question then, now, when the Constitution says the recess of the Senate, are they referring to intersession or intra-session? What are they referring to there?
I think they're referring to the short sections, which is the intersections.
Well, what does Justice Breyer say? Well, let me put it this way. Everyone agrees that this clause covers intersession, right? There's no doubt that the President can make appointments between sessions. The question is, does it also include intra-sessions? So now, what does Justice Breyer for the majority say about whether it includes intra-sessions?
It doesn't include the intersection because the intersection is too short.
No. You're going on to the next point, how long a recess has to be. In general, can a break within a session count for a recess appointment? Forgetting the length.
Yes, in general.
Okay, this is a key point. People often confuse the two. The question whether 3 days is long enough is separate from whether the President can make an appointment at all during an intra-session recess. So the first part of Breyer's opinion, right, the first part of Justice Breyer's opinion is that the President can make appointments during both intersession and intra-session recesses. Again, the phrase "the recess" is not limited to intersession. It also includes intrasession. Everyone agree with this? Now, the case was 9-0, right? If you look at the bottom line, all 9 justices agreed, Noel Canning wins. But my friends, this is 5-4. The Scalia concurring opinion, it reads like a dissent. Because he basically disagrees on almost every single point except for the bottom line. McKinney, why does Scalia think that the Constitution only allows intersession, but not intrasession appointments?
So if you kind of, basically he says it would be ridiculous if the president could just appoint people for every intersession recess, no matter how long it is. He says that would just
Well,
be...
don't get to the length yet, right? Just focus on inter versus intra. We'll get to the length in a minute. Mm-hmm. Why does Scalia think the text of the Constitution only refers to intersession? What about the word "the" gives Scalia the answer here? Puts a lot of weight on the word "the."
Well, I think he means that the recess includes like the longer one, not just...
How many is "the"? How many, if you count?
The singular.
Singular, right. So the word "the" is usually singular, right? The house, the book, the car, there's only one. So by saying "the recess," they're referring to one recess. And what is the one recess that always happens? Intersession, between the first session and the second session. So Scalia would rule on the first question that the word "the" answers the case. It refers to inter-session recesses. This would mean that the president could never make a recess appointment during the session of the Senate, no matter how long the break is. Yvonne, why is Justice Breyer troubled by this part of the holding, this part of Scalia's opinion, that the president could never make a recess appointment unless you're in this small gap between the first session and the second session? Why is Breyer troubled by that? He's very troubled.
Because it's not reasonable, and you can never anticipate when there's going to be an appointment needed. Sometimes people die, sometimes emergencies.
Very good. So Breyer says this ruling basically reads a clause of the Constitution, right? That unless you're in this brief gap between Session A and Session B, you can't make any decision, right? Alex, what would Scalia respond to that, right? Why is Scalia not troubled by the fact that there's only a very few number of recess appointments that could ever be made? Why is he not troubled by that?
Because that's the spirit of the Constitution. You're supposed to be able to...
Yeah, if the Senate's in session, say they go away for a lunch break, right? And there's an urgent appointment, what can the president do?
He can appoint.
No,
sorry.
If it's during a session and an emergency arises, let's say they went home for Christmas break, right? What can the president do?
He can do anything there.
You what?
He can make the appointment.
No, what the under Scalia's reading, can the president make an appointment during a session by recess?
Oh, no, he cannot.
So again, so he uses Yvonne's example, right? Christmas break, there's an intra-session recess, emergency happens, right? Someone dies.
Right.
President can't make a recess appointment. What can he do? What are the president's options there? It's not in the casebook.
No.
Can
he call back the...
Yeah, he can convene Congress, right? The president has the power to convene Congress. If there's action emergency, he says, hey, you lazy bums, get off your butts and back to Washington. We have an emergency here. Confirm my damn secretary. Right? So he says, there's a mechanism by which the president can convene Congress. He's never actually done it, by the way. The president never convened Congress, ever. In fact, I'll give you a little bit of background. When Justice Scalia passed away in February of 2016, this is inside baseball, the Senate was on a recess. The day he died, it was right on Valentine's Day, February 13th, 2016, I had this moment of sheer panic when I started counting, like, holy crap, they're on a recess. And I thought that President Obama might make a recess appointment. And I actually frantically called people in the Senate, and I said, you need to come back in on Monday. I don't think I was the only person. I think I was one of the first to figure this out. There were others, I'm sure. But that night, McConnell had an assurance from Obama they wouldn't make a recess appointment. He says, otherwise they're coming back in on Monday. But that blocked the recess appointment, right? But then the question I thought of, what if Obama convenes Congress to vote on Merrick Garland? Never been done before. It could happen. But this is real stuff, right? Counting these days. So, but you're right. If there's an emergency, the president can convene Congress, they come back in and vote on my guy. You don't need a recess power. Okay? Everyone with me so far? Okay, April, yeah, April. The second phrase is this phrase, vacancies may happen. What does that mean, according to the majority, vacancies that may happen? According to Justice Breyer. When, according to the majority by Justice Breyer, does it matter when the vacancy arose? That is when the person died or resigned. Yeah, talk louder.
Does it matter?
I'm asking you.
No.
Why not? Let me ask you differently. According to Justice Scalia, when must the vacancy arise in order for the president to make a recess appointment to that position? Exactly. Very good. According to Justice Scalia, the only vacancies that can be filled by recess appointment are those that happen during the recess, specifically the intercession recess. So again, with Scalia's opinion, the Senate breaks for the first session, and then they have maybe a week later the second session. Joe Smith dies in that 1 week period, right? The Secretary of State. The president can then fill the vacancy that happened during the recess of the Senate. Again, follow me. The president can fill the vacancy that happened during the intercession recess of the Senate. To Scalia, that's the only opportunity, right? The only opportunity for the president to use his power. If someone dies as a vacancy happens during the singular recess, that's Scalia. And again, look at language. Vacancies that may happen during the recess of the Senate. Here, I think there's a pretty good textual argument. The vacancy happens during that recess, right? This is, I think, is the strongest argument yet. The I can go back and forth. But say the person dies the day before the recess begins, Scalia says you can't fill that, right? Why? Why? If the Senate knew this guy died while they're in session, they can vote on his replacement, right? If the guy died while the Senate was still in Washington, they can vote on his replacement. Do it quick. But the fact that they went home and he died while they were at home, okay, that's an emergency. You can fill it there. Nick, does Justice Breyer agree with this vacancies may happen business? This second aspect of the opinion.
No.
He does not, right? Why? What does Justice Breyer say? When does it matter when the vacancy arises for Justice Breyer?
No, it doesn't. He said that it just happens to let that happen.
Okay, very good. For Justice Breyer, in the majority, it doesn't matter when the vacancy arises. The guy can die or resign before the session, after the session, doesn't matter, as long as the vacancy exists. But again, Breyer has to basically look past the text of the Constitution. He has to look at the vacancy. Well, the can mean multiple, right? Vacancies that may happen during, well, they may happen in any sense, right? It could happen before, happen later. Scalia is always a textual, so he's here at least, and he's making his points very well. So everyone get points 1 and 2, right? Scalia says only intercession. Breyer says inter or intrasession. Scalia says a vacancy must happen during the intercession. Breyer says a vacancy can happen at any time. Everyone with me so far? Okay? But now we get to the third part. And this is the part where Justice Breyer's opinion, I think, has its most difficulties of defining how long the break has to be to constitute a recess. So Carlos, right? Justice Breyer, does he give a fixed number of how long a break has to be to constitute a recess? Does he give a fixed number, my friend?
He just says that a 3-day break was not sufficiently long for the president to invoke the recess clause.
3-day break is, so 3 days is too short. What's the magic number, Carlos? Yeah, you're right. I'm asking you. He doesn't give it, right?
Yeah.
So here's what Breyer says. I'll read this quote. We therefore conclude, in light of historical practice, that a recess of more than 3 days, but less than 10 days, is presumptively too short to fall within the clause. I say it again. A recess of more than 3 days, but less than 10 days is presumptively too short to fall from the clause. Now you can imagine my sheer terror the day Scalia died. Why? Because the recess was about 7 or 8 days. Right? The Senate was in break for 7 or 8 days. He says, more than 3 but less than 10 is presumptively too short. What about 7? Is it clearly rejected by Breyer's opinion? No. In fact, I wrote a piece that weekend saying that Scalia jumping on Breyer for not giving a specific number could lead to Scalia's replacement being appointed. Right? So less than 3, more than 10, well, is 11 good? Right? Anyway, where does Breyer get the 3-day number from? Our good friend the adjournment clause. Right? Our good friend the adjournment clause, that the House can't adjourn without the Senate's permission for more than 3 days. What does one have to the other? He doesn't say. It's completely random. They're completely unconnected. Right? But here Breyer says, well, 3 days was too short in the Goldilocks, right? 3 days was too short. 10 days is probably okay. This is too cold. The porridge is no good. I can't give you more than that. There's not much of a reason why. Okay? Scalia said this is insane, right? The fact that the framers didn't give a specific number of days tells us they were talking about the intercession breaks, right? The Constitution gives days, this many days for adjournment, this many days for vetoing a bill. There are specific day requirements in the Constitution. Scalia says the fact that there were no days here means they were talking about the intercession break. There's only one, doesn't matter how long it lasts. Everyone get the holding, right? Everyone get the 3 parts of the holding between the recess of the Senate and vacancies may happen. Questions? Very important case. It's probably one of the more important separation of power cases in decades. Also, the fact that it was 9-0 wasn't even close. I mean, it was basically a 5-4, but bottom line, the president lost 9-0. For all those who say the president today violates rule of law willingly, Obama had 9-0 reversals, which I think were far easier cases for the court. Okay. Now, I want to talk a little bit about the debate between Scalia and Breyer. These two were actually very good friends, this picture notwithstanding. He looks very grumpy here. Here's a better picture. They were actually called to testify before Congress a couple times on constitutional law. It was a show. It pulled up on C-SPAN. It was hilarious. They come from very different places in the world, or actually Scalia's in a different world now, but they were in very, right now I like to think he's actually like arguing with James Madison every day. I think it's a good image for me. You're wrong. But they had very different worldviews. Justice Breyer was a staffer for Senator Kennedy for many years, and his basis was making democracy work, making your government work more efficiently. That's everything. If you read his opinion at every junction as well, the text here isn't clear, so we'll go to the purpose. And the purpose is make government work efficiency. McCulloch v. Maryland, a constitution to endure for the ages, right? This is Breyer's essence of how to make government work more efficiently. He loves democracy. He loves it. It's a word that appears nowhere in the Constitution. He loves democracy. Yeah, someone asked him what his favorite part of the Constitution is. He said democracy. Word does not appear in the Constitution, but we'll leave it there. Scalia, at least here, is a rigid adherent of the separation of powers. You saw it in Morrison v. Olson and also Noel Canning. He believes the separation of powers protects freedom, and that we start bending the rules for efficiency, freedom will suffer. And Scalia doesn't care that under his ruling, the recess power is dead. Right? He doesn't care that under his ruling, many recess appointments in the past were probably invalid. That doesn't matter to him. Breyer looks at history very carefully. He says, well, you have 100 appointments with this method. Who am I to say it's wrong, right? If there's a long-standing practice, that's the key word, right? Breyer says, if there's a long-standing practice, it informs our understanding of the Constitution. This is Justice Frankfurter in Youngstown, this idea of a gloss, right? That if Congress does something and no one objects, that's evidence that that's probably a good thing. And the court should not intervene to stop that gloss. So Breyer is very much like Frankfurter in Youngstown. We have to look to practice, look to whether Congress has acquiesced, right? President made these appointments, Congress didn't seem to mind. Scalia's like, I don't care, right? Even if Congress accepted these recess appointments, it doesn't matter because the Constitution protects the people and not the Senate. If the Senate acquiesces, that the Senate gives in to this blurring of the separation of powers, Scalia says the courts can still stop it. And this theme came up at oral arguments, in the opinion as well, but it was at oral arguments, but intransigence, this idea of gridlock. And during the argument, Justice Kagan made a very good point, right? And she said this: the recess power was designed for the age of horse and buggies, right? Where Congress couldn't come back to Washington quickly enough. But today, you can fly back to Washington and fly from anywhere in the country, right? So the problem here, Kagan said, wasn't Congress was absent, but that Congress was being intransigent. That is, Republicans did not want to put President Obama's people on the National Labor Relations Board. It was very simple. They wanted to block them. There was no and whatever else. Said, no. The recess power acts as a safety valve given that intransigence. And I remember when I was listening to the arguments here, I was like, whoa, that's a big deal, right? A safety valve, right? What does that mean? You know, the little tea kettle, right? Let some steam. What he's basically saying is that when Congress is gridlocked, when Congress doesn't want to pass stuff, the president can use the recess power to circumvent, to get around the process, you know, a little teapot, right? This argument did not go over well. And Justice Alito jumped on him and said, this is a very aggressive argument for executive power. Because it's this: if Congress doesn't give the president what he wants, he can then use executive power to bypass Congress. The majority and the dissent agreed that's a no-no. And then Chief Justice Roberts, in a quote that I've used with the Garland stuff quite a bit, said, the Senate has an absolute right not to confirm nominees. They don't have to. If the Senate chooses to just leave the seat open, they can do that. Now, this is personal to Roberts. Little known fact: President George H.W. Bush, Bush 41, nominated Roberts to the Court of Appeals in 1991 or 1992. Never got a vote. Democrats blocked the seat. A decade later, he was nominated to the same court by George W. Bush, the son. So Roberts knows well what it means not to be confirmed. He knew that very, very well. But this raises the issue of gridlock, okay? And even Justice Breyer, during the argument, said, gridlock, this is a political problem, not a constitutional problem, with a political solution. And ultimately, Obama's nominees were confirmed. The president and the Senate worked out a deal, and they got the people onto the board. He didn't need to make these recess appointments, which is why this idea of the bully pulpit, or what we call the pen and phone, or what we call today Twitter, right? The president has leverage beyond using executive power. Okay? And Scalia has this one quote in the opinion that I really like. He says, gridlock is not a bug to be fixed, but he calls it a calculated feature of this constitutional framework. And what does that mean, right? That when the president wants to put someone on the board and the Senate says no, that means the guy's not put on the board, right? You maintain the status quo, right? Congress has no duty to vote, right? They have no duty to vote. In the absence of a vote, you basically maintain the status quo. And the biggest difference between Scalia and Breyer is this: what role does convenience and efficiency play in our republic? Breyer, this is the most important thing in the world. Letting government function, get out of the way, that's what courts should do. McCulloch, Maryland, right? It's a constitution to endure for ages. But Scalia says it bluntly. He says that convenience and efficiency are not the objectives of our framework. We don't have a parliamentary republic, right? Where if the people don't like their president, they can vote, have a snap election, and throw the president out of office and have a new parliament elected. We don't have that. We have fixed 2-year terms for the Congress and fixed 4-year terms for the presidency. You elect someone we don't like, you're stuck with them. Unless you have an impeachment, which is virtually not going to happen. There are many aspects of our republic that are not very efficient, and a lot of gridlock. And to Scalia, this is an indication things are working. To Breyer, it's something that should not happen. So that's Noel Canning. a very important case. I actually, every semester I assign students to read the entire decision, a full decision. You have to read the same-sex marriage decision. I used to assign Noel Canning to the full decision. There's a lot of good history in there, which I didn't assign, mostly cut out. Okay. So what's the holding of Noel Canning, right? The president can make both intra-session and inter-session appointments, number one. Number two, the vacancy can happen before the session arises. Number three, the recess of the Senate, 3 days is too short. 10 days is probably okay, but we don't really know for sure until the court tells us for certain. Okay. Questions on Noel Canning? Questions on Noel Canning? Yes, sir.
Just to make sure if it's when Scalia died, Obama, I think he nominated, forgot his name.
Garland.
Garland?
Yeah.
And so what happened there is the Senate just...
The Senate never voted. Yep. The Senate never held a hearing, never voted on the guy. And at the end of the Congress, in January of 2017, his nomination expired. Right? The Senate has a rule that any outstanding nominations not voted on simply just expire. So Garland went back to his day job as a Court of Appeals judge.
And that was
That was it. There's nothing to stop it. Yeah, there was a very vigorous debate of law professors who insisted the Senate had a duty to vote on Merrick Garland. I said that position's insane. I went to Harvard Law School to debate. No one would debate me on it. It's very typical. So that position had very low merit. That there's some affirmative duty to vote on a nominee. There's none. The Senate can set its own rules and can decide to vote or not, and that's a decision. It's a political decision, right? People can vote for them or not, but there's no constitutional obligation to vote a nominee. I never got that argument. Yeah. McKinney.
What did you say the second and third holdings of Canning?
Noel Canning. So the first holding was that recess power works with intra-session and inter-session breaks. The second holding was that the vacancy can occur at any time, not just during the recess. And the third one, how long is a recess? Well, between 3 and 10 days is probably too short, but beyond that, we don't know. Yep. Anything else? Anything else? Going once? Going twice? All right, I'll see you on Thursday. Thank you so much.